What we as conveyancers and lawyers do is we help that situation. We help that journey. We take the burden of reviewing very hard, complex legal terms in a contract to make it very simplified for the buyer so that they understand. They won't understand time of the essence. You have to break it down for them. You have to tell them if something's due by 5, it is due by 5.
So Sneha, how long have you been a lawyer and what type of law do you specialize in?
Well, thank you, Hayder. I've been a practicing solicitor since 2016. I only look young, but I'm not, unfortunately. There's areas of the law since my admission, but now I predominantly look after conveyancing and property law.
Okay, so that means people buying and selling houses all of the time. I imagine it's a very stressful environment because we're talking about some of the largest transactions that people deal with in their lives. What do you do as a solicitor to make sure that these people feel comfortable when they're doing these transactions?
So definitely, I feel like, the purchaser or the buyer more so is probably the only person that's constantly working right from the day they identify property right until they have the keys and they are the owner. The reason is because they are the pinnacle of the conveyancing process. They are the ones that, like you said, they're investing so much time and effort into this large asset that they're going to own forever. Whether you are a first home buyer, an investor, or a seasoned buyer, process is stressful yet fun. So what we as conveyancers and lawyers do is we help that situation. We help that journey. We take the burden of reviewing very hard, complex legal terms in a contract to make it very simplified for the buyer so that they understand. They won't understand time of the essence. You have to break it down for them. You have to tell them if something's due by 5, it is due by 5. It's not due, 1 minute past 5. So things like that. We explain to them that, look, there are conditions running. They don't run when you want them to run. They run from the date of the contract. All your conditions under the contract starts today, essentially. Another thing that the buyers are not very mindful of is your deposits. They're very fundamental to the contract. You need to pay that when it's due. So like you can imagine, the buyer, when they buy something, they're only focused on finance. They're only focused on, bringing that finance approval from a bank. That's very important because we do have a finance condition. But at the same time, we as lawyers help with the negotiation. We help with due diligence. We identify whether there's a caveat on property. We look to work with the broker to make sure that, if there's anything that the finance team needs from us, we provide. So there's no hindrance in the buyer's finance process. We also look at doing other searches, flood search, easements, building and plumbing records. It's all to just make the buyer comfortable that they're making the right choice. They're buying the right house. They're buying their dream house or their dream investment. So what we do is we just help ease that pressure. I feel like a lot, but at the end of the day, we're all stakeholders here, and our job is to just make it a very seamless and smooth transaction for the buyer, right from the start till the very end.
It sounds like a lot of moving parts. What are some of the things that can go wrong?
Unfortunately, they do. There are things that do go wrong. People think that conveyancing is very easy. It's very straightforward. It's one of the easiest area. I beg to differ slightly. It's a very stressful but fun experience and journey. Stressful because you've got two opposing sides that are just doing the best for their clients. I, as the buyer solicitor, will make sure that they're buying a title that's free from all registered encumbrances. So some of the legal issues. What happens is when a contract gets signed and dated and we get the contract copy, a good practice is to order a title search. It's just to show that there aren't any surprising caveats lodged by a ex-partner of the seller or by a disgruntled family member of the seller. It's just to make sure that come settlement day, we're only looking at a discharge from the seller. We're not looking at any covenants or any restrictive easement or any caveat that might impact the buyer after settlement. Another very common issue is with finance. Unfortunately, sometimes things can go wrong. The buyers have completed loan documents incorrectly. And because of that, the banks have come back and said, nah, we're going to put a stop on the process. We're not going to be ready for settlement until the buyer satisfies X, Y, and Z. That's when we become very involved and crucial. One thing that I love doing, and I have a very big habit of, is being on top of my texts and messages, because that's the only communication I receive from the bank directly regarding my client's finance and settlement date. So if I receive anything on PAXA from the bank, it's very important I relay that to the broker and the client on the same day, just to avoid delays. Vice versa, I always encourage my broker to tell me if there's anything they've found out from the bank where I can help, just to expedite the process. Because the last thing we want is we come at the settlement date and the bank's got an issue with the verification of the loan docs. And the client gets cranky at saying that, why didn't you tell us this before? And the bank had messaged us a week ago. So, and in conveyancing, as you would know, a day makes a difference. Even an hour makes a difference. So finance is another issue. A third issue is pre-settlement inspection. Everything until the morning or the day before settlement is cruisy. Bank's ready. We've got all our paperwork. We've got verification of identities from the client. Client's funds are in place, offsets ready to go. But at the end of the day, the buyer needs to give us permission to sign off on settlement. And that's after they've satisfied of everything, including the pre-settlement inspection, which is very fundamental in my opinion. The morning of settlement, the buyer tells me, Nasna, there's a hole in the wall. Obviously, I'm not going to proceed to settlement if my client's unhappy with that. So most common issue in my eyes is definitely any issue or a very unsatisfied pre-settlement inspection by the buyer.
Can you give us any horror stories about those pre-settlement inspections, like a client turning up to a site and looking at a house that they thought was, 4 walls, windows, and a roof, and all of a sudden the roof has flown off or anything like that? Does it get that crazy?
I haven't had that crazy yet, but I've had a few funny instances and crazy moments as well, where I've had a situation where there was a frame and under the BNP inspection, building and pest inspection, we can't remove frames because they don't belong to the buyer. They belong to the tenants or the sellers. We can't really touch their belongings. So what happened, come pre-settlement inspection, the seller has moved and they've taken their stuff. Now behind this, but there was a hole in the wall, which my client now evidently can see because the frame has been removed. So the argument really becomes, was it there or was it not there at the time the contract was signed? So this is where, taking a step back, when I mentioned first initially that we play a very crucial role in reviewing contracts, because part of our contract review also is a suggestion to put a seller's risk clause. So what seller's risk clause does, it basically puts the onus on the seller right from the date of contract until the day of settlement to make sure that the property is free from any damage, any issue. Well, basically it's sustained in the same manner and condition that it was when the buyer saw it. So in this position, in this situation that I had with my client, lucky we had a seller's risk clause. So that really protected us and gave us some negotiation ground to go to the seller's solicitors and say, look, we have a seller's risk clause. I'm pretty sure it wasn't there. Otherwise, it would have been picked up in the report. As such, please fix it or give us some. So what happened was we didn't get compensation, but we had to extend settlement on a mutual ground, obviously. But the seller fixed up the wall. He patched it, he painted it, and then we eventually settled after a few days.
Okay. So pre-settlement inspection, very important. What else should buyers be preparing for in between the moment they exchange contracts and their settlements?
Well, I always describe, the way I tell my husband is, conveyancing is like a marathon. You take on with the burden, you start at the starting line and you're walking or running towards the finishing line. But along running and walking, you're also making sure that you don't falter, you don't fall, you don't break, you're energized, you're drinking water and things like that. Similar with conveyancing. You start off with appointing a good lawyer, such as myself, and you get the lawyer to review your contract for you, because there's some legal terms you wouldn't understand. So get them to review your contract, get them to negotiate. Once the negotiation is done and the contract's drafted, that lawyer helps you in fulfilling your conditions under the contract. The other thing that the buyers need to make sure is have your paperwork completed and your verification of identity with your lawyers. At our firm, we have this practice that we don't sign off until we have all the paperwork, because we're also bound by laws of law society. We also have to follow rules of Lexon insurance. So we can't just willy-nilly sign off. So that's a fundamental thing as well. We also ask buyers to make sure that you keep talking to your broker, get your finance in line. Make sure your offset account or your savings account is running. It's linked to the loan. You have permission to the bank. You have completed all your due diligence. You are satisfied with any searches that you've asked your lawyer to do. And just basically making sure that you're contactable as well. Getting the right insurance for the property. Obtaining, the seller's foreign resident withholding clearance certificate from your lawyer, things like that. So there's, like I said, the buyer is the pinnacle of the process, basically. He or she is constantly working. We as lawyers are the support mechanism for the buyer. So it's literally a lot for the buyer to prepare.
Is it possible for a buyer to go and do a conveyance by themselves?
Certainly not recommend that. You can be self-represented, but it comes with its disadvantages. It comes with its risk. Law Society and REIQ would say that you should always be represented. You can be self-represented, but until to an extent. You'll need a lawyer to do your stamp duty lodgement. You'll need a lawyer to sign off on PEXA. Not everyone is a PEXA subscriber. You'll need a lawyer to negotiate any terms on your behalf. You'll need a lawyer to explain the terms to you, because not all conveyancers can legally argue. That's why you need a solicitor. But give and take, you need a conveyancer. I would definitely not say that the buyer should be self-represented, because they're undergoing enough stress already. They don't need another stress on their head.
Okay, so I think that's quite clear. Avoid self-representing and find a good lawyer or conveyancer that can assist through that process. So I think what we need to get an understanding of is, after we have settled the property, what should buyers be kind of thinking of at that point?
Well, the most common thing that I get from buyers is, can I collect my keys? They're very excited. Now, once the matter settles and we give them the email or we give them the call that congratulations, you're not in our homeowner, they're very excited. They're not in a position to think or discuss with you anything else. All they want to know is how much money have been deducted from their account or loan, and when can they collect the keys. So apart from these things, some other things that I encourage my buyers to look out for is a final letter from their bank, if banks are involved. What normally banks do is, following settlement, they issue a final settlement letter, and that explains basically the finance side of things. So that avoids the conversation with us and the buyer, where we have to explain to them the funds and how the loan proceeds break down and things like that. The other thing I encourage my buyers to look out for is making sure that adjustments are done, and rates, telling them that, look, rates have been paid to this date, so you'll be liable to pay rates from the next quarter. Or if rates haven't been paid, then you just let the buyers know that you are expecting a bill. Please pay this because you have received a benefit in your favor at settlement.
And I remember back in the day when you got a new property and you purchased it, you ended up with a title deed, and you can say, this is my property and it's got my name on it, and you had the details of everything there. That doesn't happen anymore, does it?
No, it doesn't. Unfortunately, it doesn't. I'm a paper person myself. I'm very old school. I still love something concrete, something paper. My father still has his paper certificate of title. So that shows many, many years ago he bought his. But unfortunately, titles are now electronic. In Queensland, you no longer have a physical title. And if there's a bank involved, then the bank holds the title proceeds or the title deeds until the mortgage is paid. But it's all in electronic format.
So if I'm waiting for a letter with the title deed, I'm waiting for nothing.
Correct. You're just waiting for a letter from us saying, hi, the property is yours. We can give you a title search, which is close to a certificate of title, but basically just shows you that you're now the owner and the mortgage that's registered to your name.
Okay. Are there any issues with rates in terms of transferring that over or finding out that rates have been unpaid? And how can you protect yourself from that situation?
Yep. So that onus falls on the lawyers. So every buyer lawyer will do that at settlement. So what happens? Everything's automated. So the moment Titles Queensland is notified of a change of ownership and the settlement record has been registered with PEXA and Titles Queensland, it happens automatically. So every local council gets notified if it's a property that's sold under their local government. And what happens from there, it's between Titles Queensland and basically the council to update ownership. If it is a paper settlement, then we have to do it physically. We have to post the bank check in payment of the rates, if there were rates to be paid, and just let council know that the new owners are X, Y, and Z. But yes, everything happens. It's to avoid that same situation, that everything's automatic. You don't have to do anything. Everyone's got evidence that it's happened. These are the new owners. This has been paid. So it's accountability as well, which is why the buyers don't have to follow on us because they have records of this as well.
Well, let's go into some worst case scenarios. If you aren't able to settle at settlement date for whatever reason, maybe you change your mind, maybe you run out of money, the bank's not giving you the funds that were promised, maybe you decide to uproot your life and move overseas.
Yeah.
What can you do if you are not ready to settle at settlement date?
Unfortunately, if you've changed your mind, it's not Dotty or Potman's where you can just return the good and ask for a refund. Unfortunately, if you change your mind, you're stuck. Unlike New South Wales, Queensland contract does not allow a provision for change of mind termination. If you need to terminate because you've simply changed your mind, or if you wish to relocate overseas internationally, then we can request and negotiate mutual termination, but that also comes at a price. It does open the room for negotiation from the seller's side, where they can demand you pay their legal fees, demand you pay their marketing fees, and pay a compensation to the seller. So it's not impossible, but it's rather difficult to convince the other side because so much time and energy and cost has been invested in the transaction from both sides that it becomes harder to negotiate termination just because a buyer has changed his or her mind.
And what happens if you can't settle? If you get to that point and you just say, I can't do it, what would happen?
So if you can't settle, then unfortunately the buyer is going to be in default. Having said that, let's say if mutual termination is not accepted by the seller and the buyer is just lost or missing, or the buyer is not communicating, or he just doesn't want to proceed anymore, doesn't have the funds. That is what we call a mutual termination by the buyer, but in default. So what that entitles the seller to do, the buyer can walk away, but it really puts the seller in a position to sue the buyer for legal proceedings for breach of contract. It was decided to mutually terminate because it's not viable. Court, as you can imagine, takes longer. Any proceeding will take months before it's heard before a magistrate or a judge.
So if I'm going in to buy a property and let's say it's my first property, is there any kind of behavior from the seller that I need to be aware of that kind of raises red flags for me?
Yep. The biggest one that I've seen is when the seller is too pushy or he's asking for a quick turnaround. Normally, that to my mind means that there's something that he's hiding or something that he's not disclosing. I'm not saying that take your time, buyers. Of course, I do understand the property market is hot, and if you don't strike, there is another buyer waiting. I definitely agree with that, but I also agree that you need to do your due diligence before you put your name and your offer down on a contract, because once it's binding and becomes unconditional, like I've just mentioned, it becomes a lot harder to terminate just because you don't want to proceed anymore. So some of the behavioral characteristics that I look out for is when the agent is too pushy, when the contract is half complete, so it doesn't have information like price. That's when you start wondering what's happening here. If it goes from 800,000 to 900,000, it's a big jump.
Okay. And what about if there's a caveat on the property? Should that ring alarm bells for a purchaser?
In my opinion, yes, because I lodge them myself too on properties. So I understand the legal implications of it as well. Sale. So if I see a caveat on a title that my client's buying, I will instantly try and find out who that caveat belongs to. I'll try and join a link between that caveator and the seller and try and understand what could be the basis of that caveat. The other thing that I do is demand the agent for an explanation or just put a clause in the contract to say that the seller will withdraw the caveat on or before settlement. There is a term in the contract that does allow and give protection to the buyer where they do say that the seller has to give a title clear of all registered encumbrances, but I'd like to just go a step further and just have that extra protection for my client as well.
Okay. All right. So before we wrap things up, I just wanted to check with you if there was any other pieces of advice you'd want to give to first home buyers to ensure that there's a nice, smooth settlement.
Yep, definitely. Pick a good lawyer, conveyancer, very crucial. You'd be surprised how fundamentally important that can be to your purchase experience. We've had a lot of clients as a firm as well, where they've just said, we just didn't know what we bought because it was so seamless, it was so smooth, it was stress-free. And that's what lawyers do for you. They take the legal implications out. They take that unwanted stress out that you can otherwise deal without. Being prepared, talking to your broker constantly, making sure before you start looking at properties, have a pre-approval up your sleeve. That's very important because you get to know your borrowing capacity. You know what your offer will look like. And then when you have a contract, you're not that stressed because you're not starting from scratch on your finance approval condition. You have something to go off on. And thirdly, just enjoy the process. If you're buying the house for the first time, enjoy the process because, in this market, who knows, it might happen again or not. But if you are buying investment, first home, or a seasoned buyer, just enjoy the process, pick a good lawyer, the best even, and make sure that you know what you want. Because once you secure it, that's it. The house belongs to you and you're turning that into a home. So make sure it fits your needs and you've got the backing of a good broker, a good finance team. You've got a brilliant lawyer helping you out till the very end.
Yeah, I think that's really good advice, especially the enjoy the process because it's an exciting time, If you enjoy going shopping and buying shoes or buying new clothes, it's probably not in the same category, but it can be an exciting process if you make it an exciting process and you think of it in that way as opposed to constantly being stressed out and thinking, I missed out on this house, I missed out on that house, it can be, I guess, very unmotivating for a lot of people if they feel like they're constantly being missed out on different properties. And so people can often forget that it should be an exciting time of your life to be purchasing a property.
That's right. And I'd also like to add that it's not a rat race. Don't look at the timeline of another person buying their fourth house and you're struggling to get into the house market. Be picky because that is your big investment. It's like we said at the start, it's one of the biggest assets you'll own in your life. So make sure it counts. Make sure it's the right one. Be picky, do all your extra due diligence, put in those conditions, speak to the best team out there before you make that decision.
Absolutely. Well, thank you for your time. Sneha Chand from CJC Law. It was an absolute pleasure.
Thank you so much for having me. It was great fun. Thank you.